Hello there, ladies and gentlemen. Today in the yet another session of the Confab Lab series, we welcome all of you. And today in the panel, we have along with us Mr. R. Venkataramani, Senior Advocate, Supreme Court of India, and not to forget the master of his own subject. Along with him, we have Mr. Tarkesh Molia, Associate Professor, Institute of Law, Nirma University. Thank you, sir, for joining us. Sir, we will be discussing on the anti-defection law. In the present time, there are recent controversies which took place in Arunachal Pradesh and after that in Uttarakhand. So in light of that, do you think that the 10th schedule curtail the freedom of speech and expression and subvert the democratic rights of the parliamentarians? Because in the 10th schedule, it is written that if a parliamentarian does not vote in the line of thought which the party proposes, then he would be considered as defected. So what is your opinion about that?
Let us not mar the line of distinction between freedom of speech and expression as part of a political party and as a citizen. And that freedom which you may have to regulate when you are part of a political party inside a government, right? You have, by becoming part of a political party, given up voluntarily certain aspects of being a citizen, namely that the larger political party, by regulating the activities of each and every member of the political party, is supposed to contribute to the public good, right? So the collective conscience of the party, whether it is really a figment of imagination or it really exists, regardless of that, political parties work on that principle. So the collective conscience means I, by participating in deliberations, will yield to what I think is a certain view emerging out of the political party processes. Once I yielded to that, then I cannot later say that I have given up my freedom of speech and expression. Your freedom of speech and expression is available to you fully, let us say, theoretically, if not otherwise, fully available to you within the political party system if you have really something to contribute to what the political party ought to do. And we all understand, like in a classroom, not every member of a political party is articulate, a thinker, and an effective communicator. So let's not forget that. Then the next point, therefore, is once the debate comes within the legislative assembly, what are you expected to do? Suppose you have a point of difference with the political party thinking on the subject. Would you like to resolve it before the issue comes up to the assembly, or would you like to go and vote there? Question number one. Now, whatever has happened recently has nothing whatsoever to do with the freedom of speech and expression. It's all about something else. So let us not bring about this freedom of speech and expression and what has happened in Uttarakhand and Arunachal Pradesh. They're all not because somebody did not really have a freedom of speech and expression, but because they were expressing themselves in different ways for different considerations.
Okay. Now, one thing more I would like to add in this regard. Now, the form of government plays very important role. We have adopted the parliamentary form of government, and where the majority in the house matters. Okay. Because the one of the defect with any parliamentary form of government is of stability. Because of the defection. Defection is the one of the cause of stability. In USA, you will not find the anti-defection law because they have a presidential form of government. So one, we need to see that the concept should have an alignment with the form of government. That is the one which provides a stability to the government, which is a very essential to any parliamentary form of government. Second, the freedom which is given to the member of parliament is under Article 105 and not under Article 19. It is a privilege under Article 105, Clause 2. And when it is under Clause 205, freedom of speech, it says that subject to the provision of the Constitution, the subject to the provision of Constitution is Article 118 and not Article 19, because it is a specific freedom given to the member of parliament. And so there are parliamentary proceedings and all those things. And therefore, if you see the 10th schedule, it is the only speaker who is empowered because it is a parliamentary proceeding, and under Article 105, what is been done or spoken, they are not answerable to the court, but they are answerable to the house itself. And somebody who can expel the person on that particular ground of defection is only a speaker. So that is the alignment which the Article 105, when you read with Article 118.
So, sir, for example, there is an MP who represents, for example, Rajasthan. He is representing the people of Rajasthan. So now, for example, if the ruling party in the center is taking any decision and this is contrary to the rights of the people who are there in Rajasthan, the MP cannot take any decision contrary to what party has taken. So don't you think that there is no proper representation of the people of Rajasthan? For example, there is no proper representation of the people of Rajasthan in center just because there is some party politics is going on there.
Now, when there is a national government, the national government is formed on the basis of the national interest. Okay. You have a federal government structure. The local government issues are to be addressed at the local government. And when you have a national government, and you have a third layer of government also, that is after panchayat and that, so we have a 3 layer of government. Now the issues, and on the basis of that, the subject matters are allocated to the different governments. Okay. So I don't agree that it can be only which affect to the person of one particular thing, and if it may affects the what is to be seen is the national interest, because it is the national government. Okay. And that is why the reason is that in spite of having a federal constitution, we have a strong central tendency. Okay. Why the constitution is envisaging the most strong central government? That is also one of the question of the debate. Okay.
Don't you see that there are several structural and other assumptions behind the whole process of a political party as an institution? Concept of representation of a people by an elected representative. He is not elected as a representative merely because he is an individual,
but the party
wishing, declaring his intention to represent the interest, but because he belongs to a particular institution, namely a political party. Representation becomes real only because he becomes a part of the political party. Otherwise, he is not there as a representative. Therefore, all these structural assumptions are there. So, these structural assumptions are sometimes, to some extent, necessary to maintain a system of government, right? Otherwise, you will have unending uncertainty every time a session opens and ends, right? You may say, look here, merely because my voice is not heard, my people are going to lose a representative element in the whole democratic process. But then if within the political party system, as long as you don't find the means and methods of resolving how effectively representative one can be, and how a dissenting voice should still find a place within the political party system institution, as long as we don't move on towards those ends, this debate will be a futile debate. Because we are trying to look at it from a point of view where we say, look here, somebody is simply not getting represented. Therefore, this 10th schedule is bad. How do we reach that conclusion? There is no cause and effect, direct cause and effect connection between these two.
Okay. Sir, now you pointed out that the decision-making power is enshrined in the speaker. Sir, speaker is somewhat indirectly or indirectly related to some ruling party. So, don't you think that the power should be enshrined in some neutral body such as election commission and not in the speaker? Because it might lead to some kind of bias.
The Supreme Court has long ago said the words of speaker are not final. Okay. There is no finality now in any decision-making process.
Okay.
But the question would be, if such a person as a speaker,
okay,
mindless of his constitutional authority and obligation, acts contrary to the dictates of the constitutional principles, what should happen? Well, the same thing can happen about an election commission as well. Election commission can be as biased, okay, lack of neutrality in a given case. You only have an assumption again, election commission being what it is, it will be different from a speaker. Because the election commission has no political, affinities, and it's a completely neutral body. But let's understand that there is a very important distinction between, in any walk of life, objectivity is one thing, neutrality is yet another thing. Okay. I can be objective but need not necessarily be neutral. The two things are fundamentally different. So I don't think the answer is by putting it before the election commission. The answer is ask the speaker to be more and more politically and constitutionally accountable. If we don't have, perhaps then we can think, today government's Supreme Court said, virtually put the government back in power. Why? By judicial review power easily available, court will exercise it. There are no limitations on judicial review power. People will say, well, constitutional pundits can say, well, this is the best way to go. Okay. You give it to the election commission, there will be an election appeal, then there will be a further appellate process in Supreme Court. Why endless? Come to Supreme Court, 32, this, that, or the other, judicial review, put people back in power. Is it good? I don't know. Maybe what Supreme Court has done may also not be good.
Okay.
It is like reinstating a public servant back in service. Is it like that? Where is democracy? Where is representative character? Please ask this question. What the Supreme Court has done by reinstating a government?
Okay.
Does it meet with representative character? Because court thinks representatives chosen by people have been taken out of being representatives,
Okay.
and therefore the best way to handle, put representative character back into it is to reinstate them. Is it how we look at it?
Okay.
Do constitutional mechanisms work on these lines? I have my doubts.
Sir, now coming back to the next question, is the issuance of whip, which is issued by the political party, that should be limited? And if yes, then till what extent it should be limited?
Why should whip be limited? Whip is the prerogative of political party.
Indeed.
And what is limited in what sense? Limited by whom? Limited on what principles?
Sir, for example, if there is a person MP who belongs to this XYG party, so for example, if there are some clash of interest, then in that case, political parties do, they issue whips and they curtail the rights of these MPs. So can that be limited to a certain extent so that there is no clash of interest?
You are asking political parties to cease to be political parties.
It would be more.
When I am a political party, I am a political party. Okay. I want my political agendas, my political manifestos, my political programs to run through government,
Okay.
to run through parliament.
Okay.
You don't ask political parties to become sannyasis.
And it will be more dangerous to putting a restriction, because political parties then organize form by which you exercise your freedom of speech
So the
and
whole
expression.
question of whip, I think, is misconceived.
Is through which
Okay.
the people assemble together, form the opinion and come to the power.
Okay.
So if we put restriction on this thing, we are going to struck down the entire structure. That entire structure will become weak.
Okay.
Remember one thing, that who joins political parties today, for what ends, for what purposes? Are they there because they want to be what called altruistic, completely selfless, every moment discovering rational principles for governance and want to infuse that? Or we are having people who come for different reasons, ends and things like that. One may say, well, they are also political actors in the whole process. So let's not forget these realities. And therefore they must, if they have come in as a political party member for their own reasons, they should be subject to the regulations of the political party. They can't say, look, I complain. Walk out of the political party. Don't bring the political... Nobody, the citizen is not going to say, oh, well, ABCD has been a great leader. We have lost him because he has quit the political party. They will not say, they will still follow him or her.
Sir, there is this concept of voluntarily giving up the membership, which is one of the reason for this anti-defection. Sir, do you think that if a member has been expelled from some old party and after that if he is joining some other party, would it be considered voluntarily giving the membership?
The answer lies in your question. If somebody is being expelled, where is the voluntariness there?
But the Supreme Court has interpreted it in altogether.
Now
Supreme Court may interpret. Let us look at it realistically.
Now see, when the person is expelled from the party, now one thing is that he is expelled, now the party has a two character.
Okay.
And one is the external character which they deals with the public at large.
Okay.
Another is the anti-defection law is only applicable to the members in the house, number one. So when he is expelled from the party, say for example Kirti Azad has been expelled,
Indeed, sir.
clear? Or that matter even Jaswant Singh was expelled and many others. So when they are expelled from the political party, they continue to be a member of that party within the house.
Okay.
But for the external all other purpose, they are expelled. They are not. But within the house there is an allocation of the seats when the members are elected. But he is considered as an unattached member. But he still continue to be the part of the whip is equally applicable to unattached member also, because the 10th schedule is not protecting, or to this it is not an exception, because the exception is only merger. and the speaker in para 4 and para 5. Clear? And unattached member is not protected. So he still continue to be a member of that house only within the house.
Okay.
And the 10th schedule is equally applicable to that person also. Even he is expelled from the party.
Let's look at it from another angle. Let's say the 10th schedule is a moderating element, right? The essential minimum moderating elements in the context of political party, its members, and the possible divergence of opinions between the members and the majority or the minority, etc. may arise. So if it arises, if it has to be left completely unregulated, what happens to the actual representative process within the assembly? Therefore, the 10th schedule, I think, is what one can look at as a minimal moderating or a regulatory element. It may have some features which are incidentally undesirable, right? So, when you ask the question whether expulsion and voluntarily giving up are not two different things, well, yes, when I have a difference of opinion with the political party and I find that I am no longer able to persuade the party to see my point of view, or there are other issues with which I am not comfortable, then I am voluntarily giving up, right? But I am not voluntarily giving up, I am still putting up myself as part of the political party, despite whatever is happening. Let's say a suffocating element within the political party, but I am still not quitting it. Then I think, look here, I will not quit the political party. It's okay, something bad is happening inside the political party. When it comes to the house, I will vote against the political party or its agenda. So where does it gel together? Therefore, the political party say we are expelling you. They may persuade you to leave the political party by using means which are again undesirable. But they have, as a political party, all that means to persuade you to quit the party. So you by quibbling with words, you can say, well, somebody does not really voluntarily giving up is dispulsion, right? Can you say that? Is being
Now one thing more, when you are saying voluntarily has a two meaning. One is ethical and one is unethical. What is protected under 10th schedule is unethical, giving up voluntarily membership. Now say for example, Sidhu has resigned. So that is also, so he has quit his membership. You are voluntarily giving up membership and still you continue with the member. That is what is unethical. So voluntary giving up membership is a two meaning, and what the 10th schedule is protecting is unethically, voluntarily giving up the membership. Ethical is permissible. You resign, you get re-elected, you are free.
And if
there is no burden from the party.
And if party is forcing you to resign, would that be considered in the ambit?
Why would a political party require somebody to resign? Why?
Sir,
because you are, as an elected representative, counts as part of the number game, isn't it? Therefore, your number, if it tilts this way, the party is in jeopardy, government is in jeopardy. Therefore, they may ask you not to continue to be a member of the political party. How do you call it as a coercive element? I think it's essential part of a political democratic deliberative process. Without it, I think the engine will get rusted.
So do you think that there is any need to make certain kind of modifications, corrections, or some kind of reforms in the 10th schedule so that it can work more efficiently?
I don't think we need to tinker with the 10th schedule any longer or anymore. What is probably required to be done is look at the accountability principles of political parties and make it more democratic and said in some way accountable, in the sense the kind of people who enter political parties, who are assigned responsibilities and who are given the right to contest, it all takes place not by reason of logic and relevance, isn't it? So therefore we have problems inside the house. Why would members after election defect? Is it because they are really unhappy with the government, or because ABCD wants to become chief minister or some minister or the other, or because there is some other extraneous factors playing with that? Or you think that, look here, this political party is no longer useful to our country. Let Congress, I think, must die a natural death. Somebody thinks like that. Then let him quit the party. But if he thinks, no, I will continue to remain as an elected representative, which happened only because of that political party to which I belong. Then how do you explain this contradiction? So let's not add more into the 10th schedule and make it a constitutional muddle.
Okay. So do you have any other opinion?
No, I also have the same opinion, because it is enough, because there were certain evils which have we have deleted the para 3, which was giving an validity to the 1/3 member. That was a split, and that was the law. With the 10th schedule, we gave the permission for a group defection, and the law was prohibiting the individual defection with that para 3. And very soon we realized, and then we have to, after the Uttar Pradesh episode, the Kalyan Singh government, when the more than 90 ministers, and so 2 amendments were after that episode. One, they reduced the size of minister. Now it is 15% under Article 74. It cannot be more than 50% of the total strength of, why, as the sir was rightly saying, why people are in the politics. They want a power. Everybody want to be a minister. And if I am in minority, I manage to take 40 or 30 from the other party, because other party who is in power cannot give a birth to all them. And there are 30, 40 who are not satisfied. If I manage, I will able to form the government. So that is the objectivity. So these were the 2 things. So the number of minister has been reduced, that it should not be more than 15%. And the other thing is that 1/3 has been now no more a law, because it has been omitted, the para 3. Now what is only recognized is 2/3, and that is the merger. So I think
your question brings in certain very what called unmanageable circumstances, right? In the sense that, look here, I as a genuine member of the political party think there is something unacceptable to a particular proposal. I am not able to persuade the party outside the legislative domains, and I find that no, something wrong should not happen at all. How do I go about doing it? So do you say the 10th schedule, while disqualification exists, will also permit a member of a legislative assembly or a parliament to say, with or without the permission of the political party, to say, I want to say something in the legislative deliberations against this proposal, because freedom of speech and expression is more important. Can you provide like that? So I am not sure where it will take us, and I am not sure about that. But at the same time, it is important. Why is it important? That regardless of being subject to a discipline of a political party, regardless of the fact that I am not being able to persuade the party to see a particular line of thinking, and if I genuinely feel that no, what the government and the party is doing is wrong, which is the appropriate forum where I can go and articulate these views? Is it the assembly or outside the assembly? Now today, a wide space is available for articulating these views, but the cost you will pay is to quit the political party. The cost. So I don't find any magical answer to this question. And as I said, don't put in more into the 10th schedule than it can hold.
Okay. With the concluding remarks, this is it from this series of Confab Lab. Thank you, sir, for joining us, and thank you for giving us a new insight to this subject.
Thank you for inviting us.
Thank you.